Uh, on the behalf of Committee on MSME and Startup, I welcome CA Manish Agarwal sir, our today's speaker, and our coordinator CA Gaurav Dhawan sir. Welcome you both, sir, today webinar. So I request CA Gaurav Dhawan sir to please give a welcome note to our Manish Agarwal ji and give the introduction of it.
Thank you so much. Uh, Manish Agarwal, our esteemed speaker for today. He's a qualified chartered accountant, a resource who's had all India rank across all CA examination, a first class graduate, law graduate, a person with so many degrees, forensic accounting, fraud detection from ICI, and he has more than 13 years of experience working with Big Fours in the tax practice and also working with big conglomerates like ITC and Vedanta Group. Currently, he's the tax advisor for APAC taxation for a US based automation company that has offices in 57 countries. Manish obviously has a great experience on cross border taxation, transfer pricing, multi jurisdiction tax, startup policy incentives and funding lifecycle, transaction structuring, and due diligence. We are extremely excited to hear his views and understand the knowledge that he's going to share with us today. So, thank you, Manish. Over to you.
Thanks, my friend Gaurav and ICI for giving us the platform to share the knowledge. And I welcome all the participants who have joined on this, spend sharing their time for this Friday afternoon. Uh, to set up the topic for the today that has been allotted to me is examining the startup funding from a corporate law and foreign exchange control regulation. So I'll be speaking on something which is different in terms of not tax specific, but we will be looking at more of a commercial, corporate law and exchange control regulations of the uh, startup fundraising process. So with this note, I'll start sharing my presentation and tech team can confirm if they are able to view my presentation. Okay, yeah. So is my presentation visible? I hope. Yeah.
Visible, sir.
Yes.
Okay. So I'll start with this a very uh, a full kind of a diagram or kind of a logos which you all can see. But these are not just ordinary companies, but these are the unicorns that India has over the last few years minted. So India is a now land of a unicorns. We have so many startups that have reached a $1 billion valuation, multi-country expansion. They have huge customer base. They have made a brand in itself. And I mean, we earlier there were many, quite a few, just like Flipkart, Amazon, Snapdeal. They were some names, but now we got so many like Blinkit, Udaan, IndiaMart, as recent as Ola Electric, Delivery, iXigo, Zerodha, Grow. So these are all quite big name in itself, and they have carved out a niche for themselves. And the one reason I think it's all common of they becoming so much successful and becoming unicorn is the fact that they were able to attract significant amount of funding to fuel their expansion and growth. So the funding played a very critical part, and obviously the founder, the team, and the business model itself was great to attract the funding. But the funding is one part which played a significant role in the expansion of these companies. So now today we will be dealing with like how to do the funding, what is the process from a lens of a corporate law and exchange control, because we as chartered accountants expertise have gained expertise in such matters. So when a client comes for a fundraising exercise or an investor is looking for a potential investment in a startup, what kind of corporate law and other regulatory implications that we can advise as a chartered accountant this is something which we would be learning today. So let's see from a numbers perspective, like 23, 24, we have already 9 months down 2024, and we already witnessed large number of deals, as large as $850 million, $600 million. And these are all in a tech space, multiple space, e-commerce space, fintech space. So these are the themes which I would like to highlight, that where the currently the investors are showing interest. Primarily the hot one being fintech is one which remains top on the list of the investor. The other being e-commerce, consumer services. So uh, fintech, and nowadays we are also seeing interest in generative AI technology companies. Generative, so SaaS-based, cloud-based automation platforms, they're also gaining traction. But yeah, the startups continue to attract a huge round of funding despite a funding winter or a lack of capital, what we are seeing in the market. But still, we see large amount of deals happening all across the day in and out. And as I mentioned, the sectors which are attracting funding, fintech attracted the most amount of the funding, and fintech and e-commerce coupled with, they attracted most number of deals and deal count as well. Then there are other technology companies like edtech, health tech, like Exigo, travel companies, logistics. Deep technology is also an area which is also attracting a large amount of funding. Yeah, just an example of companies that are operating like fintech. We see Zerodha, uh, ChargeBee, Grow, PhonePe, e-commerce. Everybody would have heard of Meesho, Flipkart, Nykaa, Pharmacy on the health tech sector, EdTech, Unacademy, Upgrade, Coursera. These are all the different sectors or the tech-based companies in which the startups are working on, and they are attracting funding. Okay, so before we begin on a legal side, here is some of trends, or to set up a context in terms of what we are looking forward in next few years or down the line, of from a policy making and legal side of the how the law is evolving from impacting the startups. So there is, as you can see in the news, there is an increased bullish market already on a secondary market like capital markets, and also the investor appetite is quite large in terms of primary investment. We see huge listing gains happening for startups listing like Unicommerce, Ola Electric, and all these companies are getting listed at significant premiums and attracting significant valuation. So this uh, has a, from an investor point of view, this is obviously a reason to cheer. But from a regulator perspective, if I would say, we see SEBI issuing warnings or issuing cautions against SME IPOs, because we see sometimes that IPOs open up at a significant premium on one day, and after 2, 3 days, we see uh, they decline or erode the significant amount of the investor wealth. So to regulate this, we are seeing that okay, SEBI and other capital market, or maybe they are coming up with a set of regulations that how do we protect the interest of the investors, because there is a significant capital market and a primary market interest in the startups coming up. The other trend that we are seeing is because of this increased valuation and capital market appetite, uh, many of the startups that were earlier planning to list outside India in a popular jurisdiction like Singapore, US, London, they are now thinking of uh, getting listed on Indian capital market, because there is a significant investor appetite and the funds availability in India. So they are shifting their base from uh, outside India, wherein they have set up like in Singapore, Middle East, or London, or anywhere across the world. They are now looking back to the India as their base structure, and also the government is to facilitate this homecoming. The government is incentivizing this by introducing quite a few liberal measures like gift cities, one which is trying to fulfill the government's dream, wherein significant regulations have been liberalized and eased for listing of foreign startups in India. Cross-border merger regulations have also been liberalized, allowing uh, fast tracking of mergers. So the focus of our government is also on to liberalize the regulations for startups looking to come back to India with the setting up their base in India, because government also want to uh, increase the employment opportunity, the capital and the investor base in India. Another area from an investor point of view and is that there is an increased focus on the startup governance, because of the late recently there have been instances where large companies uh, have uh, failed on the governance parameters. There may be in edtech sector or fintech sector where a significant amount of money has been put in by the private investors, but due to uh, ill corporate governance practices or accounting frauds, uh, investor trust has been shaken down. So investors are now focusing a lot on the governance aspects of the startups by putting stringent conditions in the share purchase agreements, term sheets, putting conditions on the promoter exit, so etc., which we'll see later. But yeah, this is one trend that is shaping up the investments for the startups. Also, with the new age uh, businesses like generative AI driven business, cloud based and SaaS driven deep technology based business that has a potential to disrupt not only the conventional business, but it has also very futuristic potential. So AI needs to be regulated as well. So we've seen a lot of policy discussions happening at Ministry of IT and Technology and Communication on the how to develop regulations around AI. With the AI so prevalent, there is a lot of concerns about data breach and privacy protection. So laws around data protection and privacy is also coming up. We see a digital competition bill coming up. So all these regulations are targeting or focusing on the new age businesses, which we are yet to see how the law will come up and evolve. Now, coming back to the topic and the subject of our discussion for today, uh, looking from a funding, from a corporate law and exchange control point of view. So before we delve into the corporate law and other legal implications for the funding, let's see some of the basic aspects of the funding, the investment process, and then we move on further with the considerations from a structuring point of view. What are the relevant clauses in the agreements, investments that are typically negotiated between the investors and the promoters? How do we see the governance and oversight? How we structure the exit? Then we sum up and see the legal and regulatory framework under the Companies Act, under the Foreign Exchange Management Act. And then finally, we conclude with some tips and useful for future fundraising engagements that the members may have. So, funding, I would say, is a mix of four important components that we got. One is at what stage the fund is being raised. Is it because that's how we come to know that whether it regulations needs to be complied with or not, or what is uh, and to be upfront dealing, we will not be covering it today here, the IPO level, or we will be covering the private placement funding and not the exit or the IPO fundraising process, because that's a different story altogether and it's a different length of discussion. So we'll be dealing mostly on the private placement side, which is the most uh, I will dominant way of raising investment before company gets listed. So from a stage of company point of view, like if it's a company is at a very idea stage or a nascent stage, generally there is a seed capital that is being raised from friends and family, or sometimes it is a bootstrapped company, we call it. Then as the company grows and it gets market traction, the company raises capital, which is generally called growth capital, or I would say the first round of investment capital. We can see stage two is growth or expansion capital. And then when the company gets mature, uh, there is generally a IPO or exit round of capital, which we are not currently dealing here. So what we will be dealing mostly is stage two, when the company is at a growth stage, and they want to raise a capital in the form of an equity from investors like private equity investor, angel networks, venture capital, because they are the a set of investors who are formalized set of investors, because when you are at a very early stage, generally it's you may at times see that even the company is not yet incorporated, but still they get growth capital from seed capital from their friends and relatives, because that is generally an informal relationship driven capital or a transaction, not a formalized one. But we as a chartered accountant, we come in picture more if, when there is a need to formalize the things, to put uh, things on track from a legal point of view. That's how our requirement will come in and we come into picture. So if I talk about the formal set of investors, or that generally startups approach for seeking investment, one is typically, uh, I would say it's not particularly in the order, but let's say angel investors, like who are typically high net worth individuals, or they are generally the co-founders of large companies, and who have taken the exit and now sitting on billions of dollars to make investor common names in the Indian startup ecosystem, like Flipkart co-founder Sachin Bansal, Binny Bansal, Zerodha's Nikhil Kamath brothers. They are the ones, I mean, Mukesh Bansal from Myntra. They are the ones who are making a lot of significant deals, and Ratan Tata is also one which is making significant amount of investment in Indian startups. There is also a dedicated, uh, I would say, incubators or accelerators. They are kind of a school, I would say, that mentor the startups and fine tune their products and the processes, and help them define their market, and also help them uh, meet the investors relevant to their target group. And so, basis that they help startups to find the investors and get the funding. The other set of investors typically are family offices. So they are the family office is the one that manages the wealth of a particular large business group. Let's say Wipro Family Office Group, or some other large in corporate. So family office objective is to manage the wealth of the family or the particular corporate group, and they often look for the opportunities in uh, startup sector, because startups has a potential to multiply your wealth manifold. If it turns out success, you can take an exit at 100x or a 200x return. Sky's the limit. So family offices always, I would not say always, but they often look for such opportunistic bets where they can multiply the wealth. And the other is I think the traditional one, venture capital fund, the private equity funds. They do invest in unlisted equities with the objective of taking an exit and making multifold gains. Like recently, we saw Titan Capital taking exit from Urban Company by making 111x returns. So yeah, and Blackstone, we see InfoEdge, they making an investment in Zomato. They exit at a significant premium. So venture capital fund and private equity fund, they are generally uh, they invest at a quite a early stage, or I would say at a growth stage, and they make an exit at upon IPO or a significant third party funding deal. Alternate investment fund are also, I would say, are technically a regulated name of a private equity or any of the fund who gets registered with SEBI and gets a license to be an investor management. They can take a or AIF license. So there are three categories of AIF: category 1, category 2, and category 3. So you need to have a SEBI registered license to become an AIF, and you can make investment in unlisted equities. Then there are also offshore funds, private equity funds that come in India and allow and do FDI. So whenever a foreign investor comes in India, that investment is generally treated as an FDI. Okay. Yeah. And so the other thing which I would also like to discuss here is what are the types of instrument that are generally preferred by startups at the time of fundraising, and that is also preferred by investors. The common one being equity shares. Yeah, uh, you give the share or percentage of the ownership of the company to the potential investor against the consideration. It could be in the form of cash or other than cash. But yeah, it has a potential to dilute your equity percentage. Uh, then there is a compulsory convertible preference shares, compulsory convertible debentures. So preference shares and debentures are also preferred generally by the founders and promoters because it does not dilute your equity immediately, but at a later defined stage, the equity is diluted. At the time of raising of funds, equity is generally not diluted because they are preference shares and debentures, which does not count as a current shareholder, but at a later defined date. Then there is also a third category, which is a venture debt, more or like a debt, but with some elements of convertibility and some options given there. So it is a kind of an exotic debt. The third and the fourth one option is the convertible note. It's also a form of a debt or a convertible instrument, but it has some greater flexibility compared to the CCPS, compulsory convertible preference share, or CCD. So convertible note can only be issued at the moment by an eligible startup that fulfills the condition of DPIIT. Convertible note is not eligible as an instrument for other companies. So it has a greater flexibility. You need not to convert it now. It can be repaid into a year of 10-year period. So it offers a greater amount of flexibility compared to the traditional CCPS or CCD instrument. So how does the funding process works, or how does, when we say the funding, how, I mean, this is more from a point of how does an investor or a fund gathers the funds. So they gather the funds. You would have seen the news that like typically large funds, they first pool the funds from multiple. So they mobilize the fund, which is the technical. So they mobilize funds from multiple channels in India, high net worth individuals, or from outside India. And then there are typically in a fund structure, two kind of partners are there. One is a limited partner and the other is a general partner. General partner is the one who is involved typically in the fund's daily management and investment process and entity selection, the investee entity. So whereas limited partners are more or less interested not in the operational management of the company, but they are more uh, on getting their returns from the investment. So general partners, in addition to the returns on investment, they also get a investment management fees, which is generally called as a carried interest in startup terminology. So these are typically the fund structure is like they mobilize the funds from various sources in India, outside India, even India. Now we have a gift city option, so you can set up a gifts your AIF in gift city. Then you have partners, general partners, and limited partners. Now let's move on and see what is the typical investment process when a deal comes into a startup or investor comes into. Uh, how does the investment process looks like, and how much time it typically takes to close a deal? Okay. So as you can see, it's a lengthy process. So with 8 steps. Maybe not necessarily eight, it can be six, seven, or eight, but yeah, typically these are the steps or sequence followed. when an investment, a potential investment deal is to be uh, uh, concluded or materialized between a company and an investor. So the first step, very basic step, I would say, I would combine investment evaluation and preliminary negotiation as one step, wherein the parties, the investor and the company, or the co-founders and the promoter, they get to know each other. Basically, they determine whether the investor and the company is a right fit for each other or not. Because it's not just about taking a money, because uh, startups are typically in a very early stage. They are people driven and promoter driven companies, because a lot depends upon how the caliber and the attitude of the promoters. Whereas also the startup wants to know that whether the person who is making investment, the VC or a private equity, whether it will impact the day-to-day functioning or autonomy of the startup. So both the investor and the investee entity, they need to know, uh, uh, arrive at a conclusion whether they are a right fit for each of them. And if they come to this conclusion that yes, they are a right fit for each other, and yes, there is a synergy involved, then they determine that okay, from the funding that we are going to receive, what is we are going to achieve from the funding, whether it could be the expansion, or whether it could be going to a new market, or it could be R&D work, or whatever the goal, and whether these goals or these end uses resonate with the investor. Because sometimes investor has a different expectation or has a different business strategy. So you need to align with each other, that whether the business goals and the strategy of the promoter and the investor is on a same page or not. If yeah, if we come to the thought that yes, both the investor and investee can work on the common goal together, then they move on to a next step, wherein they they see how we can share the risk. Or because equity investment in a startup is a risky investment, but given that uh, start startups are quite at a nascent stage, and someone putting a risk, they don't want to take all the risk by themselves, the investor, because they are putting the capital, and they are also taking a significant amount of risk. So generally the startups agreements and the process is designed in a way that risk can be shared between both the parties, or to a to an extent mitigated from investor and moved on to the investee or to the promoter or the founder. So we will see how the risk is mitigated or shared between the investor and the investee, because startup has an inherent risk of failure. Yeah, so as I mentioned, so uh, this investment process or is more about achieving a synergies and achieving, I would say, creating a win-win situation. And apart from investor and the investee uh, fitment, sometimes we also need to consider about the regulators. And if the deal is happening through a leverage deal, we also need to think about the financiers to the deal, the banks or some other investors, and also who all are other stakeholders in the deal, like advisors, regulators. So if you are working on a deal which is in a highly regulated sector, like a media sector or a fintech or a banking sector, we need to also see that whether this deal is feasible from a regulatory point of view or not. So there comes the regulations and the regulatory aspects, uh, which needs to be analyzed also, apart from the investor and investee relationship. Now coming to the first formalized stage of the funding, or I could say the investment process, is a term sheet. So this is a very basic, I would say, uh, uh, like a non-binding document it is generally, wherein uh, each of the party signs the piece of a paper, wherein they write down certain terms and conditions which would form the foundation of the investment which the investor is going to make in the company. So the terms and conditions would be like who would, what would be the type of security there, what kind of controlling rights would be given, whether there any anti-dilution rights would be given or not. What would be the conversion right if it's a convertible instrument, if there is any special veto right or a voting right is being given, that's also there. What is the valuation or the price which is there? So these are, I would say, very basic, I would say, foundational structure of the investment. And on the basis of this, due diligence is generally conducted. And so due diligence is, I would say, the lengthiest and the most important step in the entire investment process, because on the basis of due diligence only, the investor can get to know about whether the things that have been promised or that have been shown in the pitch deck is actually making sense and it's real or not. Because people tend to overhype things in pitch deck and during the meetings, because you don't have any means to validate those facts and those commitments during the meetings itself. So due diligence is like a, I would say, factual uh, finding and validation of the things, because only if you have the evidence that things are in real, you can make a decision and determine the right value or the price that you're paying for the investment. And due diligence is generally across the areas of the company, like legal, uh, uh, it, your HR, your finance, tax, general operational due diligence. Each of the area, different aspects are covered. Like in legal, we see any litigation of the company, whether the titles to the properties at the company, whether the company is complying with the privacy regulations, whether if you are in a media sector or a tech sector, whether you are complying with the IT sector or not, are there any impeding litigations or there or not, HR, whether there are right policies, whether the labor laws are being compliant with or not, are there any non-compliances in the HR area. From a finance point of view, whether the financial statements and the information on the which forms the basis of the valuation, whether that information is reported correctly or not, whether the underlying assumptions for preparation of the financial statement is true and is as per the industry practice or not. The common examples, like if you have an aggressive revenue recognition practice, whether that revenue recognition policy is correct or not, because sometimes the valuation is based on the multiple of our revenue. So that valuation forms a very fundamental thing, and the revenue being one of the input there, you need to check upon the revenue recognition policy, whether the actual cash conversion recycle, sometimes that's their working capital. So all these finance related items are examined during the financial due diligence. Then of course we have tax due diligence, wherein we see the tax positions taken by the company in their tax returns, and whether that position is aggressive or is it subject to litigation, or sometimes a company has not taken a particular incentive or a benefit or a tax advantage. So all these issues are highlighted during tax due diligence. And then we see the operational due diligence, wherein we see whether the operations of the company are carried out uh, in a efficient manner and not. What are there any, I would say, inefficiencies in the business or not. The process wise, whether the company is following correct processes and good practices. So the scope can be very wide for the due diligence depending on the investor and investee comfort. And yeah, and the other thing is also on the background check on the promoter or the co-founder, because these co-founders, they are the fundamental. Startup is nothing without its promoters or the co-founders. So an investor bets not only its money on the business of the company, but also on the promoters or the co-founders of the company. So their uh, integrity, their background check is something which we are seeing that is increasingly becoming more important to the investor community. Now the next step is you finalize the documentation. Documentation by mean we finalize the agreements like share purchase agreement, share subscription agreements, shareholders agreement, and employment agreement. After we arrive at the due diligence findings and these whatever needs to be incorporated in the agreement as well, basically the due diligence findings, the agreements are there. So share subscription agreement, if we were to distinguish between uh, quite confusing terms like share subscription agreement, share purchase agreement, and shareholders agreement. Generally, share subscription agreement is for the first time or a primary issuance when a new share is issued. And so there the new investor is subscribing to the equity of the company. Whereas in a secondary transaction, when you are buying from a one investor, then it's more of a share purchase agreement because there is no subscription involved. So and uh, to be noted that the both these agreements, share purchase, share subscription, and the shareholders agreement, they are all tripartite agreement wherein not only the existing investor and the new investor, but company is sometimes also being made part of the overall agreement obligations. Even though in a secondary transaction, company has a no role, but still uh, investor invest and the company are is being made part of the overall investment agreement because there are certain obligations on the company as well, so which are being defined in the agreement. And shareholders agreement is typically a kind of, I would say, a master agreement or a framework agreement which governs the obligations of the investors, shareholders, and the company towards the company. Then if the co-founder is also working in some capacity in the company like a CEO, CTO, or a CMO, then we also have a promoter's employment agreement. This has been recently been we seen that becoming popular. Earlier it was not so popular, but yeah. So promoter's employment agreement is also becoming so. This agreement particularly defines how the conduct of the promoter as an employee, being CEO or CTO or in whatever capacity, his remuneration, if he wants to leave the organization, what is the terms and conditions he under which circumstance he can leave, what would be his ESOPs or ESOP pool. Uh, I mean, typically, what the way the company and the co-founder wants to define their terms and conditions for the employment that they want to continue. We have also seen that investors are nowadays, because of the recent fiasco and corporate governance lapse, we have seen investors are seeking a significant amount of disclosures in representations and warranties uh, from both the company and the promoters and the co-founders, confirming that they are complying with the corporate governance matters, they are complying with the tax issues, they don't have any tax litigation or any litigation, and if they have litigation, that is being disclosed to the investors. And I mean, everything related to your conduct of the business, operations, finance, legal, they seek confirmation and the representation from the promoters that they have disclosed everything to the potential investors, and there is nothing to hide, and whatever they are doing is in good faith. There is so to protect the interest and to cast the liability on the promoters and the company, we've seen that these kind of disclosure requirements are being put in the agreements. Now, the next step is I mean, once we have the documentation being formalized, then there is another important in the uh, clause in the document, or I would say important part in the document is conditions precedent. So condition precedent is that without these conditions being satisfied, the investment cannot move ahead. But depending on these are generally the findings of the due diligence report and certain other like obtaining regulatory approvals, and I mean doing certain uh, uh, tasks uh, like removing one particular management or obtaining regulatory approvals or any other thing that happens commercial based on the commercial understanding between the parties. This could be, I would say, a roadblock kind of a thing, wherein if these uh, actions do not close by a certain date, then deal cannot move. So conditions precedents are like that. So they need to be drafted very carefully, and they should be drafted in a manner which captures and secures the interest of both the parties, whoever you are advising. If you are advising an investor, you need to draft accordingly. And if you're investing a client or a co-founder or a startup, you also need to uh, analyze and understand that the terms are not in a manner which would put you in jeopardy. So this is one such clause which we need to be mindful of and to watch out for. Closing conditions are such that they are not, I would say, this is different from conditions precedent in a sense. You need to perform certain actions at the time of the closing. Uh, they could be like preparation of the financial statements as on the closing date, or uh, like doing certain uh, regulatory actions or to perform the filings, but they are not the one which can impact the investment round. So it is, I would say, a lighter than the conditions precedent, but yes, you still need to comply with those conditions, because failure to comply will subject to you the uh, legal remedy or recourse in the investment agreement. Conditions precedent, subsequent, these are the conditions that you need to comply upon the investment being completed. Like there may be certain actions like which could form part of the due diligence report, which are not of very serious nature. But let's say if there is a lapse on the filing of a return or a file, maybe particular intimation to the authorities or stuff like that. I mean, you can do it still even after the investment being completed, but uh, without this actions being taken, still the funding or investment can happen, but yes, they need to be done after the closing of the funding round. So yeah, so once we have the closing and the subsequent conditions, we can say that investment or a round is completed. We see that generally the public announcement is being made even at a term sheet stage or at a, because they have secured a funding round. So generally, yes, signing of a term sheet uh, is, but it does not guarantee that a funding would definitely happen at a valuation stated in the funding, because after the results of the due diligence, your valuation may drop. But generally, we've seen that in the media and social media and public press releases are being released even at a term sheet stage. But technically, the funding gets closed when all the agreements are signed and the amount is, I mean, paid to your bank account. And sometimes as a part of a condition present, amount is even not paid to your bank account, but it is paid to your escrow bank account. So you need to see, especially in case of listed company, this issue becomes relevant from a disclosure to stock exchange and the compliance under SEBI insider trading regulations. Where at what time you would say that investment is completed and at what time you need to disclose. This is a judgmental call and a factual call which you need to see depending on your listing agreement and SEBI regulations. So let's see what are the structuring consideration, or because we've seen that how the process works. And but as I mentioned earlier, so investment round or investment process wherein you need to align the goals of the different stakeholders. From a regulatory point of view, you need to align the stakeholders coming from promoters, investor groups, your employees. I mean, so all these matching the expectation of all the stakeholders uh, is something we need to do as an advisor, as a legal advisor, as a tax advisor. And
Manish,
yes,
sorry to just interrupt you. After stakeholder PPT, can we discuss some questions in between?
okay, if we have the questions, we can.
Yeah, we have around 10 questions.
Okay.
So
Okay.
I can share with you.
Yeah.
Okay. Okay. I will
Yes.
share.
Looks like we have a lot of interest in the subject. Uh, yes, shared on this chat only. Okay,
WhatsApp.
yes, given on the WhatsApp. Okay, I can take one.
Okay.
Okay, let me take what is unique about unicorn. Okay, so the first question I think is what is unique about being unicorn? I would say nothing changes in terms of the business as such. It's just a, a, a number or a threshold that is generally considered as uh, a special in that particular club because $1 billion valuation is a significant milestone that is considered in the startup ecosystem. But with now so many startups in the unicorn club, I would think uh, this status is somehow getting faded. But still, considering a country like India, wherein so many the population of 140 crore and making a mark of $1 billion valuation is something achievable and special and deserves attention, I would say. And then what makes a unicorn special? As I said, uh, the special thing about being unicorn is not achieving the unicorn status in itself, but more about, I would say, operational excellence, the impact that you're making on the customers and the society, how unique is your product, what is the problem that you're solving for the society, could be anything. You may not be solving any problem, but your business model is very great, like Zerodha is one perfect example, a bootstrap company, but still $1 billion valuation and revenue. So what's make them special is could be anything, could be your product, could be your man, could be your team, could be your delivery method, could be your problem solving techniques. Anything could be special about the unicorn. uh, what do you understand by the leverage ratio and the solvency ratio? I mean, leverage ratio and solvency ratio, these are uh, generally considered to validate the liquidity position of the company, and how leveraged company is to see the whether the company is in a capacity to pay its debt, and in the event of liquidation, whether the company will be able to repay off its creditors and debts, and whether the company is in a position to meet its interest expense, whether it is profitable enough or not. Uh, can we explain the cost of capital? I think I can explain, but that's not the subject of for today's discussion, cost of capital. But still, uh, cost of capital is generally the discount rate, which purely, if I see from a mathematical and financial management point of view, the cost of capital is the uh, discount rate that goes into to value your uh, cash flows in a discounted cash flow model. So cost of capital is the CAPM method, which is generally being followed, which is and this component comprises of a risk-free rate and a market rate multiplied by a factor of your beta. This is what I understand so far. But yeah, I'll be happy to answer more on the financial management side, but I think this is not the topic for current discussion. What are the main types of funding? The main types of funding, as I mentioned in the instruments type, it's like we could have a equity, pure equity funding. Then we have a convertible funding like convertible preference shares, convertible debts. Then we can have a debt funding pure play. And then there is also a venture debt kind of a funding, which is like a mix of debt and equity. What is the most common source of funding? I would say most common source of funding is uh, your first bootstrap funding, your initial friends and family generally comes in as a first round of firm, but that's only up to a seed stage. But after the growth stage of capital, you generally go and reach out to the private equity and angel funds and accelerators. Yes, but private equity and I would say generally comes when you are at a more at a profit stage, but generally at a very initial or a first stage or a second stage, uh, venture capital, like angel networks, or I would say accelerators are the ones which are commonly approached by startups. What is the purpose of a convertible note? And I think these are the questions. I have a specific slide dealing with a convertible note later on, but we can discuss it. But convertible note main purpose is that it protects the equity of the uh, co-founders for a longer period of time, because that's the intent of the government introducing convertible note. Because in CCPS or CCDS, you need to convert your equity within a defined time zone, and your equity dilutes very quickly. Whereas in a convertible note, you get a period of 10 years. So we'll explain this in the convertible note at some point later in the presentation. But I hope I have answered questions, Devangji, and I hope are there any more, or we can move ahead. I think we can move with the
Yes,
presentation.
sir, it's over. You can move, sir. After half an hour, if there are any questions, I can share with you. I share with
Okay, okay, okay. So yeah, so as I was discussing we were discussing the topic about the structuring of the transaction. So why there is a need to structure a transaction? Why we cannot? Why we can just not move the transaction in one particular manner? And why there is always? So as I say, every transaction is a unique transaction. There is, why? Because there are different stakeholders involved in a transaction, and there is a different set of investors expectations of the stakeholder. The one set of investor may would need a different kind of thing, and other want a different. And you may employees, then you have regulators, the promoters. So all these things make it the life of as an advisor and the transaction complex, and that's why there is a need for of a advisor for the transaction to give the path that what is the right form of doing a transaction that achieves the goals of all the parties involved in the transaction. So as I mentioned that the first point of structuring is what is the particular instrument that we would like to go, whether we should go with the private placement, whether we should go with the bonus, right issues, sweat equity. I mean, every instrument has a different mm, purpose and a different characteristics, and it has a different uh, objective. Uh, so, like for example, if I have an existing set of investors, I want to raise capital from them only, I can go for a right issue. Whereas if I want to attract a new set of investors, I can go for a private placement. If I want to issue shares to my employees for the services that they are rendering, ESOP. And why someone would say that ESOP is a funding? Because by issuing ESOP, you are saving cash that you would have otherwise paid to your employee. So ESOP is also a mode of funding, as well as it is also a mode of rewarding your employee by making him participate in the future profits and the future upside of the business. Then sweat equity is also another mode of funding, or I would say by making your other parties, like other than employee, as a part of your ownership. If you have taken services, valuable services from a consultants, advisor, and at a startup stage, if you don't have enough cash, but you can pay them by equity, so this is also kind of a funding. So these are the different ways of the funding, I would say. And then obviously there is a choice of instrument which we have, like preference, convertibles, equity, convertible note, and debt. So this is the first, I mean, a decision that we need to decide what kind of issue it would be. Then the other decision is whether it should be a primary investment or a secondary investment. So the ones which we have looked upon here are the primary investment. Then there is a secondary investment. The key difference between primary and a secondary investment is in a secondary transaction, the company does not get any funding for the in its bank account, because uh, in secondary investment, existing investment investors are only taking a they are selling their shares, and they get the money from the new set of investor. So company does not get any money. So and so this is what we need to determine, whether if the need of the company is to go for expansion, then obviously the primary investment is the route. Whereas if the objective is not to uh, uh, get the money at this stage, but basically to replace one set of investor with another set of investment, or then I think secondary investment is something which is followed. It also depends a lot on the parties as well. Where sometimes primary investment is a process which is generally a lengthier process, because issuing shares in the company, you need to take approvals and compliances. Whereas in a secondary transfer, I think the process is a lot faster. The company, the investor gets the money quickly to the other investor's bank account, and he becomes the shareholder. And it may at so happens that the investor may do a combination of a primary deal and a secondary deal, wherein uh, the amount of secondary investment could be less, and the primary investment could be more. So it depends on the factual circumstances of each case. But there is one downside in secondary investment generally, that there is always a dispute to a title sometime. I mean, if, for example, if there is a dispute to title or a future indemnity or a liability that arises to the shareholder, to the company, because if you have taken the control of the company and let's say some liability come in, then uh, generally in a secondary transaction, the the transaction generally happens between the previous investor and the new investor. So how do we make the liability of the investor enforceable on the company? This is something which we really need to think about, and that's the reason, as I mentioned, we make the agreements as a tripartite agreement, wherein both the seller and the new investor and the company are made party uh, to the investment agreements or the shares transfer agreements. So as I said, the investments could be in the form of primary investment, wherein we do a fresh issue, or it could be a share transfer or a secondary investment, or it could be a mix of both, wherein some part may be more or some part may be less, depending upon the individual goals of the transaction. Then we see the how do we structure the transaction from a jurisdiction point of view, whether it should be a onshore structure or an offshore structure. So if I explain with the help of a diagram, so offshore structure is the one wherein the operating company remains in India, but for the purpose of bringing in funds and holding, uh, we bring another layer of entity in some tax friendly jurisdiction, or maybe other well regulated or investor friendly jurisdiction. And from that entity, the money is invested in the Indian entity. In this example, let's say the founders and the investors, they are based out of, let's say, Singapore. They incorporated an entity in Singapore, and that Singapore entity in turn makes investment in Indian company. So this is one structure which is commonly followed up till, let's say, last few years. But now we are seeing that uh, investors are more or less preferring the direct structure, wherein they do an investment directly in India without any external structure, or and somehow investors are now also moving to a structure by flipping their existing offshore structure into onshore structures through reverse flipping, which is a concept, and wherein they uh, uh, merge their overseas company to the Indian company, or they do a share swap. So that's a complex set of transactions that they do, which we are not discussing for today's topic. But these are the structures that are typically followed for investments. And based on the actual case and the facts, we need to see where we want to do a offshore structure or an onshore structure. each of our structure has some basic advantages and pros and cons. Like if we want to do a offshore structure, obviously there was a reason of mm, tax planning which was earlier there. Like if you're investing through Singapore and Mauritius till 31st of March 2017, your investment gains were grandfathered. So that's the reason most of the companies were investing through Singapore and Mauritius. But after the Mauritius tax treaty amendments, and also the fact that India's capital market is booming up and the valuation, the gains are since anyways taxable in India, so investors are preferring to come to India directly through onshore structure instead of offshore structure. Whereas in an offshore structure, countries like Singapore, there is a better protection for under the intellectual property regime, better corporate law, ease of doing business, infrastructure. So uh, we need to make a trade-off between all these things and uh, how the things pan out in this particular manner and decide whether an onshore structure is preferred or an offshore structure is preferred. Now, if this is another a technical concept, but uh, related to the structure of the transaction only, whether the funding structure should be uh, uh, the fund that is, like say, a private equity fund is coming to invest in Indian operating company, whether the fund should, in the example, let's say, invest directly in the Indian company as an foreign direct investment, or sometimes it may happen that private equity firm, instead of investing directly into Indian company, they set up a alternative investment fund in the gift city, and that AIF in turn makes an investment in Indian company. The reason I think is would be because the FDI regulations, uh, sometimes the compliance with the FDI regulations and the capping on the overall compliance with the FDI policy makes it difficult to, if you're tapping up the foreign market. So uh, making an investment through AIF in Gift City and other domestic AIFs makes it possible to, uh, uh, I would say, structure the transaction by in a manner which is flexible with the pricing regulations under FEMA and also under the invest sectoral cap under the FEMA FDI regulations. Now, this is another interesting concept. Let's say uh, uh, you have seen in the news that sometimes multiple investor comes to invest in a single private investment as a round of investment. Let's say uh, Flipkart is raising, let's say, for example, $500 million as a funding. And in that round of funding, let's say $100 million is being invested by five different private equity funds. Now, each of the five different funds would have a different set of investor expectations. They would have want a different voting rights between them. So, structuring transaction in a manner which achieve objectives of all the investors and is something which we need to see. Like by you may issue sometimes a different class of shares to them, or you may put them into a different investor group and have the specific investor rights to a particular set of investor and sometimes do not. And also we need to see if a transaction of such a large scale is coming, like whether any regulatory approval is required, like a cabinet approval, MC approval, RBI approval, or a competition commission of approval. That is also we need to see. Now we see what are the key legal clauses in the share purchase agreement or shareholders agreement or share subscription agreement, whatever the agreements that we have seen. What are the clauses that are there and which would require us to uh, pay special attention? So the first, I think, the clause is investment in tranches, which is sometimes we call it as a earn-out transaction. So earn-out or investment in tranches means that uh, in order to protect the interest of the investor, because let's say there is a total requirement of funding of $600 million. And uh, and in the pitch deck, it has been shown that the funds of $600 million would be used, let's say, for expanding into new markets in, let's say, US and uh, Europe market, and to open up new office for investment in hiring and bu- and okay. So, but in order to protect the interest, let's say investor puts, if everything is put it uh, at one go in the company, it is quite possible that the promoter or the co-founders may misappropriate the funds, or they may siphon off the funds, or there is a corporate governance issue in that sense that then entire $600 million may come at stake, and there is a risk of losing out. So to protect this, and there is generally the investment is done in a staggered manner, wherein a milestone is defined at what particular achieving milestone, or at on what stage the investment is needed, and on that basis the investment amount is released from the escrow account upon approval and the discussion with the or everyone in the investor community. So this is the one investment in tranches, wherein uh, investment is made not at one go but at a multiple go based on the milestones defined. So as an advisor, a legal advisor on each of the party, we need to define the in very clear terms what could be the milestones, what is the exact process of drawing out the funds, uh, what approval is needed, and uh, so that the interest of the investor is protected, as well as if I'm advising a co-founder or a promoter or a company, the company also does not suffer due to too much approval and the process, because business need money at sometimes at urgency. So those kind of contingencies also factored in. Reps and warranties, we discussed this earlier as well, but yeah, reps and warranty is kind of a confirmatory statements from the promoters and the company that they have disclosed everything and there is nothing to hide, and they undertake that every information is disclosed. If anything later comes in, they undertake to take the full responsibility, which is covered in the indemnity point, wherein uh, sometimes we take specific indemnity from the promoters and the company, wherein it is stated that anything related to the past acts, let's say prior to investment being made or prior to the share transfer, would be the liability of the seller entity or the company, and they agree to indemnify uh, to the new set of investor, because since they have taken the exit, the litigation will be continued in the name of the new set of investor, or they would bear the cost of the litigation and the cost of any legal damages. So any such cost which is related to the past events would be indemnified by the seller entity. Liability clause is generally the limitation of liability, wherein it is agreed between the parties that in case of any default or damages being their liability would be restricted to, let's say, the amount of consideration they receive, or a certain multiple of a consideration, 0.5x, 0.1x. It depends on the commercial negotiation, but liability is generally, I would say, related to the indemnity clause only. Non-compete is similarly, uh, let's say you have given an exit to a promoter or a co-founder, uh, and but even after giving the exit, let's say promoter does the same business, so it would impact uh, the business of the company in which I'm investing, and I would be making losses if the promoter is doing same business and soliciting my customer. So to protect my interest as an investor, uh, there is usually an agreement in the clause, share transfer agreement, that for certain period of time you cannot enter into the competing business, and the competing business is also defined very specifically, and also sometimes there is a consideration also being paid for the non-compete. And non-solicit is similar to non-compete, wherein you will not solicit the clients in a similar business. And yeah, and founder lock-in. This is also a unique clause and generally found particularly in startups, wherein yeah, if I am investing in a startup entity or I'm making a secondary investment, there is generally a clause that the founder of the company will remain with the company for, let's say, 2 years period. This is usually to again, because as I said, that's the a startup is dependent on its promoters and its business. So an investor bets on the co-founders. So the presence of the co-founder is necessary for the success of the business and for the protection of the money that the investor is putting in. So generally these lock-in clauses are there that founder will remain with the company for a certain period of time. Veto matters, again, there are certain matters where investor would say that if I have a veto on these matter, it means even if I have a less than ordinary majority required under the company, that let's say I don't have a majority of 51% to pass a normal resolution or a 74% to pass a special resolution, but still uh, on certain matters like business restructuring matters or uh, let's say hiring a key management person or let's say expanding to a particular market, I would have a veto, meaning that if I do not agree with a particular decision, you cannot move forward. So these are very carefully designed decisions which we need as an advisor need to think more from a business and a commercial perspective as well as from a regulatory point, because these can lead to a significant amount of litigation if not drafted properly. Then the breakup fee, say that is in case uh, the agreement is terminated for some reasons or there is a breach of contract, what would be the damages that each party would have to pay. Then there is also a clause on dispute resolution and jurisdiction. This is also very relevant and important because a lot of times dispute happens and parties are unable to uh, resolve within the Indian court or within the even the alternate dispute resolution courts like Singapore Arbitration Council. So it has to be defined very clearly that which party will appoint the arbitrator if it is going through an arbitration route, what will be the seat of the arbitration, uh, what would be the mode of arbitration, uh, how the arbitration award will be settled. All these things on a dispute resolution point of view has to be also from designed considering from a futuristic standpoint of view, because you know, agreements are drafted only for the purpose of future. I mean, they can only be used when there is a dispute. If there is no dispute, there is no use of agreement. But we have to draft in a manner that if there is a dispute, the agreement should clearly state out the intention of the parties and the expectations very clearly. Any questions if we have got so far? I would be happy to take, or I can move forward. Devangji, questions? Any?
Yeah, sir, there is some questions I will just sharing with you. Just give me a moment. Shall hardly only 4 questions. Sir, I have shared you.
Just a second. Okay, so the first question is how a fresh company or idea go for seed funding from a group of companies. Question is not clear, but still I understand that how a new company or can go for a seed funding. Uh, there is obviously a formalized manner. One is the Startup India policy, wherein if you are a DPIIT registered company, you go can apply for seed round of funding under the Seed Fund of India. There are also multiple banks that offer seed funding, like SIDBI offers seed funding. In addition to this, you can go for accelerator programs or incubation program, wherein if you have a brilliant idea and a brilliant people behind your idea, you can pitch for your idea with any accelerators, or there is a list of accelerators available on the Startup India government website. You can reach out to them, pitch your idea, and if you get a meeting, you can get a funding. Sometimes we don't have high net worth friends and family, then how can we proceed? As I mentioned that there is a Startup India government scheme. There is a accelerator network, potential network. You can also go to the startups conferences and meetings and network with the people and get to the right stage of funding. What is the difference between a normal debt and a venture debt? So normal debt is a pure vanilla debt wherein you have a fixed interest obligations and a repayment obligation, whereas in a venture debt there is a mix of uh, normal debt and certain conditions, like it can be converted into equity, or there is a variable payment of structured payment. There is a flexibility available wherein you can combine the features of equity and debt in a venture debt. Secondary investment useful in which situation? Secondary investment is useful in a situation wherein uh, I would say uh, the company, the co-founders does not, one of the, let's say there are three co-founders in a company and you want to bring in a fourth investor. Yeah. But uh, if you don't want to dilute your equity in a particular situation, because if you bring your fourth investor, everyone's equity gets diluted. So if you don't want to dilute your equity and if you want to give an exit to one of the investor, the third one, you can bring in the secondary investment, because in a way the existing investors, the one and two, do not lose out their equity, and the third one gets an exit. But it is not useful in a situation when you want to bring in the capital infused for the growth of the company. Secondary investment is generally given used to give the exit to the existing investors, because the company does not get any money in the secondary investment round. Okay, I think we have covered the questions. Now let's move to the remaining parts of our topic. And okay, so we have covered the key clauses in the agreements. Now let's see. I think this I have already covered, that the investor enter into a deal on the basis of representations given, and uh, they generally seek voting veto on the key important matters, and uh, they generally want a lock-in for promoter, because they want promoter to stay in the company for a certain period of time. Yeah, and uh, company, the risk that a promoter that faces generally is that uh, let's say the company raised some amount of money from a new round of investors. They may have some apprehensions that everyone knows the Bharat Pay episode, and there is you know, the new set of investor outspitted the co-founder of the company. So the co-founder always has a risk that their shares may be diluted and they may be ousted from the company. And so these are the basic risks that investor or promoter has, that they may lose out the control from their uh, company. And also there is a risk that they have to make every single disclosure to the investor, or and they also feel that in case of any future claim comes against the company, the promoter can be held liable. So these are the risks that, or the apprehensions that are in the mind of a promoter or the co-founder, which we need to discuss and address appropriately in our legal drafting. Now let's see in a agreement what are the rights that investors generally or want or negotiate. So one is governance right, that is they want a seat on the board of the directors so that they can approve and be a part of the key decision of the company. Then they also want transferring rights such as tag along These are called derivative rights like tag along rights, right of first refusal. So tag along right is a right wherein they say that if one of the promoter is let's say taking an exit at a significantly higher round of valuation, then they want that they should also be given exit first before the any existing investor comes. So this is kind of a transfer right. Anti-dilution right, again to protect their shareholding, they would say that they cannot issue shares at a valuation lower than the value at which the existing investor come in, because if they issue shares at a lower value, they would be able to higher number of shares to the new investor, which could dilute the shareholding of the private equity investor, venture capital investor, or a third party investor. So they want that the new round of investment should not be lower than this particular funding round of valuation, which is generally called a round down valuation. Unless there is a business need and the business has genuinely gone down with the valuation, you can do it. But generally, if it is done to in a good faith manner. If it is not done in a good faith and if it's done to uh, uh, dilute the shareholding of the investors, then this clauses can be triggered upon. Right of first refusal is generally the right which is given uh, that if any of the existing investor is taking an investor, then before selling the shares to any third party investor, the existing investor should be given an opportunity and they should be offered these shares first before any third party comes into picture. Preemptive rights and affirmative votive rights, these are generally the rights which are given as a veto, a matter of veto. So veto rights are, as I mentioned, that even though you don't have the majority to pass the ordinary resolution or special resolution, but still having a veto, and you can get block the resolution, and these are generally given through amending your articles of association and your charter documents. And there could be other such rights like restrictions on the transfer of shares, other general corporate rights, approvals, intimations, who, but all the procedural rights can be given to the investors. Yeah. Now let's take some of the restrictions that are put on the co-founders and the promoters in the investment agreements. As I mentioned, generally a lock-in period is introduced in the agreement to ensure the continued employment and engagement with the company. Then right of first refusal, offer obligation to offer their shares to the investor prior to offering them to any third party. And then there is also a restriction against non-solicitation and non-competing, and then consequence of termination of their employment. Also, the we see sometimes that if the employment is terminated due to fraud or due to breach of trust or any other such reasons, which like moral turpitude or uh, any uh, uh, unlawful practices, then even the ESOPs or the shares that they have been given, it could be forfeited. We have seen this happening in past in the media for some large fintech companies, wherein the promoters leave the company on the charge of unlawful doing activities, and as a result, the company forfeited their ESOPs and the shares which have been given to them. So, yeah, these are generally the restrictions and obligation imposed in the agreements. Now, governance rights, we've seen and discussed, I think, that uh, the investor group is given a right to appoint a board, nominee director, or observer. They can participate in operational decision making through board of directors. They are given the veto rights. Yeah. And also we've seen that some specific clauses being put, like confidentiality clauses, to say that none of the company's confidential information is disclosed to anyone who is not intended to have access to such information. Kind of non-disclosure agreements signed with each of the promoters and the co-founders, that this information about the company and its operation, the confidential information, should not be divulged with anyone except the persons who should have the access. Then uh, the investor generally get their rights to appoint and hire the key management personnel and doing their feedbacks and the reviews. Now let's see, uh, uh, when an investor comes in, what are the management consideration, or in terms of uh, how do we reward the key management personnel or the employees who are part of the company since long? So how do we reward them? Through equity or a share-based payment? So the one method which is traditionally being used and it's still being relevant is an ESOP, employee stock option plan, wherein you have been given an option to buy the shares of a company at a grant price, which is usually a very significant low amount, and uh, the price that you pay is called the exercise price. And generally there is a condition being put that you need to render the service for a certain period of time before you become eligible for grant of share or exercise of a share, and that period is called vesting period. After the vesting period is over, you get the shares of the company at a price defined in your grant agreement, which is called the exercise price. So it is kind of a perquisite which is taxable under income tax as your income. And yeah, and company also gets a deduction for this expense. Stock appreciation right, it's also a same like ESOP, wherein uh, you give the benefit of you know, uh, uh, the appreciation in the price of a share between the grant date and the exercise. But the only difference is there is no share being issued. In ESOP, against the payment of the exercise price, employee gets the shares allotted in his name. But in stock appreciation right, there is no actual issuance of shares from the company to the employee. It's just that the equivalent value of the share is being paid to the employee. So in this way, the share capital of the company is not altered and the existing investors' shareholding does not get diluted. Then there is a third category, which is sweat equity shares, wherein we can reward employees, consultants, and other people for the services that they have rendered or for the know-how or technical intangible they have supplied to the company. We can reward them on the basis of the shares. So I have prepared a comparative tabular summary between ESOPs and sweat equity so that we can see what's the difference and understand more the technical nuances. So ESOPs, I said, ESOPs can only be issued to the permanent employees or a director, whether whole-time director or not. But independent director, we cannot issue ESOPs. Whereas sweat equity is issued to the directors or employees at a discount or for consideration at other than cash. So we can issue ESOP to directors or employees at a discount or for a consideration other than cash. ESOPs, uh, there is no particular consideration. ESOPs consideration can be zero, but for sweat equity, usually there is a consideration element. It can be in the form of a cash or other than cash. Sweat equity is generally issued for providing the know-how or making available the intellectual property rights, whereas ESOP is given to employee for rendering the services to the company. Eligible startups can issue equity shares, can issue ESOPs to their promoters, promoter groups, and to directors holding greater than 10% of the existing paid up capital of the company. Whereas startups can issue sweat equity shares not exceeding 50% of its paid up capital up to 10 years from the date of its incorporation. So they cannot issue more than 50% of their capital as sweat equity shares. What are the challenges in ESOP? Challenges is that it cannot be issued to non-employees, whereas in sweat equity, challenges is that it cannot be issued to non-directors, employees, and obviously if it is issued for a consideration other than cash, then there is a challenge on a valuation, that how the valuation is to be done, whether GST is applicable or not. Whereas in ESOP, the challenge is that there is a tax element on the exercise as well. Whereas at the time of exercise, the employee practically does not get any benefit, but still employee has a cash outflow in terms of a payment of a perquisite tax under income tax. Now let's see some of the valuation aspects of the funding. The valuation, the price is under the Companies Act, the valuation is done by a registered value. So for any share issuance in the form of preferential allotment or private placement or we are doing, then the price has to be determined on the basis of the valuation report of a registered valuer, and you cannot issue shares at a price which is less than the price in the valuation report of a registered valuer. Along with this requirement, you also need to give a explanatory statement to your shareholders, which will form part of your resolution approving the share allotment, and you need to give a relevant date. So your valuation date at least has to be 30 days prior to the 30 days prior to the date of the general meeting of the company in which the shares are proposed to be allotted and the resolution is to be considered. Now, how do we value the convertible securities? So convertible securities are like convertible preference shares or a debentures or convertible note. So for these kind of securities, you need to determine a conversion ratio. Conversion ratio is like for every 5 convertible preference shares, you will get, let's say, 2 shares, equity shares of a company or 3 equity shares of a company. So how do you determine that conversion ratio? By doing the valuation of the instruments, both equity of the company, and on that basis, you will determine the conversion ratio. The valuation has to be done at the time of issuance only of the convertible security, even though the conversion may happen later, let's say 15 months, 18 months, 24 months, the period as per your agreement. But for convertible security, the price of the or the ratio of conversion has to be defined now at the time of the issue of convertible security. At the time of conversion, the actual price may be different, but you cannot issue shares later on at a price which is less than the price which is determined now in the conversion ratio. So the decision has to be taken, the upfront decision has to be taken that what would be the conversion ratio on the basis of the valuation of the underlying equity share. And okay, and if you are doing the valuation of how do we do the valuation of convertible security? That if we are issuing convertible shares to the foreign investor or a non-resident, in such a case, we need to apply the pricing guidelines as per the FEMA rules, which say that price cannot be less than the price as per the internationally accepted guidelines. So it can be any DCF method or any other method which has to be done by a chartered accountant or a merchant banker. And again, as per company law, the valuation has to be done upfront at the time of the issuance of convertible security. The price at the time of conversion cannot be lower than the fair value worked out at the time of issuance of instrument. So the conversion ratio and the valuation of the underlying security has to be done now only. For securities that are issued other than cash, the valuation is also required to be done by a registered valuer under the Companies Act, and registered valuer has to give a detailed report to the company giving justification for the value. How does he arrive? Let's say I'm giving shares to the director for, let's say, for his services as a advisor or a consultant. So, but then how do we do the valuation in such a case? Then registered value and will do the valuation, and basis the report of registered value, the shares will be issued for a consideration other than the cash. Now this is very important, and I think the stage of investment, which is called exit stage. So whenever an investor makes an investment, he plans to do it with the mind that he will make a X amount of return at the time of exit, because investment is always made with an expectation of a return on investment. So how do we plan the return on investment? Could be either in the form of periodic returns through debt, through dividends, or through interest, or through others, or buyback, or it could be at the time of the exit. Generally, in the case of startups, since they are not profitable uh, for a longer period, dividends are usually not possible. So because dividend you can declare only out of the profit. So how do startups plan their exits? They generally plan their exit through IPO or a secondary sale or a buyback, because that's how they can make the money out of it. Because by the time the company is at an IPO stage, there is a significant attraction and a valuation that the company has at gain, and the investor make capital gains on the valuations gain. So this is how the generally the exit is planned at IPOs. Uh, but when we do the IPO, or when a IPO is being planned by the company or the investor, we need to look at certain clauses in the agreement, like whether there is any lock-in period for the promoter and the investor. Also, SEBI has introduced certain restrictions that to protect the investor, that even after the IPO is being launched, the initial investor, for a certain percentage of their equity, they need to still be there on the company even after IPO. They cannot sell 100%. So there are certain regulatory restriction under the SEBI issue of capital and disclosure requirement regulation, as well as under the investment agreement. If you have that, if there is any lock-in requirement even after the exit, or if there is any restriction on the secondary investment exit, like we discussed certain rights like tag along rights, drag along rights, right of first refusal, or a promoter lock-in. So if these are the lock-ins, then exit needs to be planned accordingly. Then there's still the transfer, as I said, that there could be apart from IPO, there could be a secondary sale to a strategic third-party investor as a secondary investment deals. Then there is a drag along right option, wherein this involves sale of all shares of the investors to a third party by dragging or obliging other existing shareholders to sell their shares to the third party. So drag means you are forcefully telling the other investors to sell their shares to the third party along with the anchor investor. This right is usually given to and exercised by investors if all the other options fail. Means you're not getting a buyer in the secondary market, you're not able to take a IPO or a strategic sale. Then we say that, okay, sale of shares. And why sometimes we go for a drag along ride, because sometimes the new investor who wants to buy the shares of from a existing investor may want to have a controlling stake in the company, whereas the person who is selling the shares does not have a controlling stake. So in order to make the deal more attractive and the more viable, this right is exercised so that the controlling stake can be sold to the new investor. Then the next is the buyback option, wherein if the company has a surplus cash, then the company can buy back the shares from the existing shareholders and extinguish the shares of the company and give a kind of an exit to the shareholder. Now let's look at very broadly some of the legal framework under the that is applicable to the startups fundraising. The first is, of course, the Companies Act, which governs the corporate law framework. Then Income Tax Act, which governs your uh, direct tax implications for any fundraising on both the investors and the company and the promoter. Then for listed companies and at the time of exit, it becomes important to examine the SEBI regulations related to the issue of capital. So takeover code is particularly relevant for a secondary transactions in listed companies. AIF regulations if you're planning to set up an alternative investment fund in India. So SEBI AIF regulations are important there. Then FEMA is also relevant from a Foreign Exchange Management Act from a cross-border. If the investor is coming from a foreign jurisdiction, then Foreign Exchange Act and the FDI policy is also relevant. And who all are the regulatory authorities in India dealing with the funding process? Ministry of Corporate Affairs for doing the forms and the filings. Then we got Reserve Bank of India for filings under the FEMA Act. DPIIT for approvals under the Startup India scheme or any benefit or incentive that we want to avail under the Startup India scheme. SEBI for regulatory and matters related to the listed companies. Competition Commission of India is also applicable for certain very large deals like above 1,000 crores or 2,000 crores. If there is any acquisition deal, then Competition Commission of India comes into picture. For certain sector specific deals like financial sector, insurance sector, or a pension sector, we have specific developer regulators like Insurance Regulatory Development Authority, Pension Fund Authority. So they are the sector specific regulator. Apart from this, there could be many sector specific regulator, like we got TRAI for telecom matters, or other authorities for depending on the sectors in which the business operates. So this is a slide which I prepared specifically to discuss about some of the emerging businesses and the regulations, because the our law needs to evolve with the uh, new businesses that we are seeing, and especially with the startups and the tech business coming up. The regulations also pose a challenge. How to regulate these businesses also challenging. So, like fintech business, they involve combining the regulations of RBI along with the cross-border money transfer, as well as KYC regulation. We have seen the instance of what's happening with the Paytm. They failed to comply with the KYC regulation, and as a result, their business suffered a huge losses. So, all the if you are in a fintech business, always comply with the KYC regulations, the RBI specific guidelines for the license under which you are operating. If you are under the online gaming business, we need to comply with whether you're gaming complying with the gaming laws of this particular state. If you're on online gaming business, you also need to see whether you're complying with the privacy and the data protection rules, whether there is no illegal or money laundering happening, because we have seen that uh, uh, a lot of gaming companies coming under the scanner of Director General of Intelligence and ED for AML and KYC. Like, for example, Mahadev Betting App was the recent example. We've seen crypto companies and blockchain companies also coming under the scanner for AML and the cyber security. Like in the recent news, you have seen that WazirX, crypto exchange, they suffered a huge losses like of $234 million because some amount was stolen from their offshore cryptocurrency wallet. So cyber security laws and IT technology laws, these are relevant. Then, of course, if you are into of crypto and blockchain, fintech regulations, RBI regulations on regulating cryptocurrency, digital wallets, and prepaid instruments. So all these is, I would say, a mix of technology and law that is coming, and it's very interesting to see how these policies and law will evolve over the period, especially with the generative AI coming in, AI and the ethics, the Digital India Bill, the Digital Competition Bill. These are all the upcoming regulations that we are seeing, and which we see as an interesting confluence between the business and the regulations. Now, just on a broader note, what does the Companies Act provide when we do a fundraising? Or it provides a comfort that the relevant laws of the land are being complied, that the internal approval by the board of directors and the shareholders of the company as set out in the is in place. We are complying with the resolution. The registrar of companies is being informed. The relevant shareholders approval is in place. So Companies Act, all this is validate all your actions, make them in, prescribe the procedures, how to do the fundraising or how to do the share transfer activities within the four corners of the company law framework and your articles of association and your charter document. Whereas FEMA law and the FDI policy, it defines that in which sector we can invest into, and which sector requires approval, which sector is prohibited. So the FEMA does that. And let's see what is the process of a private placement, which is the most common route for investment that is being followed by startup companies. So private placement is governed by Section 42 of the Companies Act and Rule 40 of the Prospectus Rules 2014. Uh, private placement requires approval by way of a special resolution, and it needs to be accompanied by a explanatory statement and valuation report of a registered valuer. And your the money that you have raised by way of private placement cannot be utilized unless the filings and the return of allotment is completed, and you cannot do a subsequent round of private placement unless you have uh, completed the previous round of private placement and or it has been withdrawn. And you the maximum number of investors that you can reach out in a year for investment is 200. So if you have breached that limit, you cannot go for a second round of a subsequent round of a private placement. So you have to comply with the 200 investment limit. Now let's see very briefly the FDI policy, and I think this would be last slide from my side. That, as I mentioned, FDI policy is for automatic route and government route. There are two routes. Certain sectors are under automatic sector like financial services, e-commerce, B2B trading, agriculture, manufacturing. Certain sectors comes with a government approval route. Government means cabinet approval, like multi-brand retail with uh, you know, 51% capping is allowed, and public sector banking FDI is allowed with a cap of 51%. So we need to see the FDI policy circular issued every year to determine whether if the sector which the startup is operating, whether any approval is required or if it's a government or it's under the automatic route. While most of the technology sector, e-commerce in which startups are nowadays operating, it's under automatic route, but we still need to look upon the particular sector and the FDI regulation. For e-commerce sector, I would particularly like to mention that under e-commerce sector, the investment can be made only if e-commerce is operating in a marketplace model. I repeat, and they cannot do a inventory model wherein it means startup like e-commerce entity cannot hold the inventory in its own name. It can act only as an aggregate or as under the marketplace model. So I think this is from a famous side. Let's see more from some practical tips and things. Closing thoughts. So as I mentioned, startup funding is not just uh, getting the money at a valuation, or it's more about achieving the synergies between the target company investor and its promoters. And this is the key, I think, thought we should always keep in mind. And never underestimate the process of due diligence. While it's the most
Uh, Manisha, there is some question which I have shared with you on
okay. Let me see. On what basis one decide raising funds from debentures, CCDs, or RPS. So, as I said, debenture is kind of a debt. So, debentures comes with a fixed obligation. Uh, I'm hope it's not written convertible. So, debentures are generally they are pure debt. So, if company does not have cash flow initially, then the debentures cannot be issued. But CCDS, yes, it's a mixed of hybrid of uh, uh, convertible and debt and equity. So CCDs can be issued, and generally CCDs are issued when we don't want to dilute the equity, but at the same time we want to retain we don't want to have a repayment obligation fix. So CCDs are preferred over equity if we don't have the cash flow. Uh, then debentures are not advisable. Then I think CCDS is preferred because then we have the feature of equity as well as uh, no repayment fixed obligation. What are the two emerging modes of business? I didn't exactly get that, but mode there could be businesses anywhere like fintech is the business, agriculture, electric vehicle, semiconductor sector, manufacturing. There could be a number of businesses. Every business is emerging in India. What are e-business and outsourcing referred to? Why are e-business and outsourcing referred to as emerging mode of businesses? Didn't again get the question, but yes, they are the sunrising sectors. They are attracting most amount of investments. I think they are generating most amount of employment in India. They are getting most amount of FDI in India. So I think they are the emerging business, but it's not that only these are the emerging businesses. Every business can be emerging, and there is particular time of a business to boom. What is the significance of e-commerce in a? I think these are questions which are more, I think, Devangji, related to the economics in general or macro level questions we can take up later. But what are the two main types of external business growth? Uh, Again, I can think is the cryptocurrency safe? What are the biggest threats to cryptocurrency? Uh, let's I mean we can take up later. I don't think very much related to the subject. Cryptocurrency safe. Do invest and let us know your thoughts on the cryptocurrency safe or not. We yet no, don't know. RBI does not endorse cryptocurrency. So yeah, we can conclude the session.
Okay, so sir, I request our coordinator Gaurav. Gaurav sir, please give the vote of thanks to our speaker, Manish sir.
So, thank you, Manish, sir. I think it has been great to hear this session. You've discussed each of these items in so much detail instead of delving into these matters that are very relevant for every business and understanding in terms of CAs who are working with startups and helping them raise funds. So it was very enlightening, even things that even I didn't know. I heard very carefully to understand and enlighten my own self. Thank you so much for this wonderful enlightenment session, and I hope everyone has a great takeaway from this.
I give
Thank you.
thanks to CA Manish Agarwal sir and our coordinator CA Gaurav Dhawan sir. Thank you so much to be a part of this webinar. Thank you,
Thank
sir.
you.
Thank you.
Thank
Thank you.
you.
Thank you.
Give me a wonderful session.